Commerce in the state of Florida. I'm representing the U.S.-Colombian Business Partnership today. It is a partnership of very diverse industries. They have invested over $9 billion in Colombia. It was first formed in 1999, and the purpose was to enhance commercial security and transactions and to help crack down on narcotics. We not, as a business, just drop in money or invest in it. We create jobs, we build roads, we put Colombians to work, and we help them grow their industry. We work with universities and we provide high-tech training. Member companies in this nonprofit partnership have been in Colombia for nearly a century. And I can tell you, as a company greatly involved, we have seen remarkable transformation, especially in the last 6 years. The acceleration of positive changes is taking place everywhere. I want to talk a few minutes about the benefits of passing the U.S.-Colombian trade agreement. No one claims the FDA would adversely affect the United States. As Ambassador Schwab said earlier, presently 92% of products from Colombia into the U.S. come in duty-free. What this free trade agreement would do is provide U.S. companies with the same benefit. Putting off FTA cuts off significant benefits to the U.S. As with Peru, it would create jobs here and there. Now, I've heard an argument that this isn't a significant agreement. Well, I'll just pick one company to use an example. Caterpillar. Caterpillar makes all kinds, as you know, construction trucks, etc. The market for Colombia and Peru is a larger export market than currently the UK, Japan, and Germany and Brazil combined. That is a huge market. And the day this agreement passes, on the large trucks, that 10% tariff currently being paid by the U.S. companies will disappear. That's resulting in a $200,000 per truck benefit to the U.S., U.S. citizens, the ones who work in Caterpillar, as well as the general economy. Significant. And what does the U.S. give up in return? Nothing. Not a thing. There's no change on our side. Now, I can tell you, as someone deeply involved with international efforts for Nortel, the high-tech jobs are incredibly important. Exports are incredibly important to us. We currently we're in 150 countries. We have 15,000 employees in the United States, everywhere, from California, virtually every state. And it's become increasingly challenging to compete in the global marketplace because our competitors in Europe and Asia have been signing free trade agreements. Those companies have an advantage over U.S. companies. And the time has come to help U.S. companies remain competitive. This free trade agreement is a simple way to do it. Right now, the U.S. companies are caught in the middle. When you've got other countries and other regions signing these agreements, and we can't get it ratified. Now, not only does it help us, but it helps us greatly. It helps sustain the economic growth in Colombia. When Colombia's economy grows, crime and violence goes down. The economy right now is $130 billion in Colombia. It grew 6.8% in 2006. But mark my word, if we don't pass this agreement and we discontinue watching that growth, you will see an increase in guerrilla violence, self-defense forces, narco-traffickers, and they'll be competing for billions of dollars if that's where the job creation would be. Saying that Colombia has to do more before we recognize them with a free trade agreement, not only counterproductive to us, but it's like a doctor saying to a patient, "You're too sick for me to see you. Come back when you're feeling better." It's just absolutely absurd. What this does, it enhances a lot of things important to U.S. companies and therefore their employees. U.S. trademarks, patents, copyrights. It enhances intellectual property enforcement, and it allows for an intelligent, consistent way of solving disputes. Put into law, people need to know that there is a way to resolve disputes. Some of you in this room know that Nortel was involved in a very big dispute with Colombia many years ago. And a lot of the congressional offices here, and the administration, and a lot of other people, including the ambassador that was just here, were very helpful in getting that resolved. What this free agreement would do, it would prevent those things from happening in the past. With new protections, it allows investors to bring claims for alleged breaches. It enhances the sanctity of contracts, and it's less political and more legal and business-like. Again, I say, economic slowdown will lead to more violence. Delaying passage of FTA will stop violence. It becomes the best cure for economic growth, and the FTA is the best vehicle. I find it very difficult to comprehend why we wouldn't do this. I mean, it's obviously good for the U.S. It's always good for U.S. businesses, and people work for U.S. businesses. At the same time, it enhances the stability, the economic future, and people see hope and an alternative. This is clear, folks. This is not a tough call. We see studies constantly correlate between telecom availability and decreased violence. We see greater prosperity and greater security going hand in hand. So it also has, I can tell you this as a former Commerce Secretary, it has a multiplier effect on developing the economy. It helps develop an infrastructure that enhances speed and information, helping people communicate to their authorities and educate through their school systems. It makes their businesses also more productive. And I know the arguments, but the fact is that labor standards continue to improve. And I might say right here, American companies have played a role in this. You know, we don't just export our products. We export the same labor standards we adhere to here in the United States. And as more and more businesses do that, it's the proverbial all ships rise. And it's just a simple thing to do. Companies bring standards and practices to Colombia that improves the economic environment there. In summary, we urge Congress to move the Colombia Free Trade Agreement as quickly as possible so U.S. firms, employees, and the people of Colombia can reap the benefit. Under the Free Trade Agreement, 80% of U.S. exports of consumer and industrial goods would be duty-free immediately. Others would be phased in over a 10-year period. Again, to reiterate, the increased competitiveness of U.S. companies with European and Asian competitors only continues to grow, allowing certainty by providing rules to binding arbitration is an answer and a plus. We hope members of Congress will recognize and will adopt quickly. Thank you for your time and your attention.
Thank you very much. Angela Ellert, who graciously at the last minute agreed to appear on the panel, is not able to join us this afternoon because of the House's consideration of the Andean trade preferences legislation. She is required to be there. I'd like to note also, in terms of the balance of the program, we tried to have someone from the Ways and Means Committee or the Trade Subcommittee representing the Democratic majority appear on this panel today. People, for one reason or another, made a decision that they did not want to speak publicly at this event. I think what I would like to do, since we have one fewer speaker and we still have 3 speakers on the second panel, is take maybe 10 or 15 minutes of questions and break a little bit early and therefore start the second panel earlier to give 3 speakers equal opportunity to present their side of this issue. As before, if you have a question, please identify yourself and speak loudly because we don't have a microphone to share. Questions, comments? You should stand up and speak loudly, please. Thanks.
I'm Steve Barr, the American University student. You had mentioned that, I had the translation, but that in order for a country to be successful, they have to reduce their labor costs. I wonder, does that mean successful for whom? Because the only way to reduce your labor costs is either to employ fewer people or to pay people less that you already are employing. So obviously then it's successful for business, as Mr. Farmer's pointed out. Business obviously benefits from that because they have to pay labor less. But is it successful for the people who are being paid less? And as you mentioned, don't have health care oftentimes and aren't getting allowed to form cooperatives. Thank you.
Is there another? We'll take one more question and then turn to our panelists. Why don't you here? Pass the microphone down. Or stand here if you prefer, whichever you prefer.
Entiendo muy bien. Utilicé la palabra reducir costos. Lo que quería decir básicamente era optimizar costos. El optimizar costos laborales implica en ocasiones básicamente cómo la calidad y la eficiencia de ciertos trabajadores se puede ver compensada por el conocimiento que ellos incorporan en los productos que estén generando. Y eso por lo general lo que hace básicamente es que genera costos laborales estables, ¿no es cierto? Y una ganancia que tiende a crecer en el tiempo. Cuando uno mira el mercado laboral colombiano, se da cuenta de que como todavía tenemos productos de primer nivel, ¿no es cierto?, que no tienen grandes valores de conocimiento, la única forma de uno poder ser competitivo frente a un mundo que tiene países grandes como China, como la India y muchos más de toda América Latina, donde se compiten por costos laborales, se da cuenta uno de que efectivamente, así a uno le interesa incrementar los salarios básicos de la gente, uno lo puede hacer por la calidad del producto que exporta y que ofrece. Lo que queremos hacer en Colombia básicamente es incrementar el nivel de educación y de activos de los colombianos para que podamos generar productos que efectivamente paguen mejores salarios. Y si uno se pone a mirar, el SENA, que es una institución que depende del Ministerio de Protección Social, ha venido incrementando su número de personas, una cobertura de 1 millón a 4 millones de personas en los últimos 4 años, de personas formadas en nuevas vocaciones o técnicas en aras de que puedan tener un trabajo que tenga una mejor remuneración y una mejor calidad. No podemos esperar que Colombia se quede indefinidamente solamente produciendo bienes de primer nivel. Y en esta etapa, retomando el punto de inicio, cuando uno viene y reduce el número de trabajadores, en aras de poder tener mejor tecnología, en lugar de esa eficiencia que manejaba al principio, que también ocurre en el sector agrícola, naturalmente que los trabajadores se ven afectados. Pero de nuevo, cuando se hace ese cambio, se necesita gente que esté mucho mayor capacitada, y la que está mucho mejor capacitada, por lo general, tiene mayor formación. Entonces la apuesta va hacia allá.
I guess I'd like to add, in the case of Nortel, and I suspect most of the U.S. corporations doing business in Colombia and Latin America as a whole, our employees have health benefits. They have vacation time. Now, like I said earlier, perhaps not as clearly as I should have, we don't change the rules from one country to another. So there may, I think the other point I wanted to make is that as you put that into a country and a culture, then the logical competition within that country raises standards because employees choosing between a company that has benefits and one that doesn't, it's a clear differential. So again, in the case of Nortel, we do. So hope that's helpful.
Well, that could be Nortel, but with all due respect, that could be Nortel, but like, what about companies like Coca-Cola, where there's no question that companies like Coca-Cola and others do not agree to the same standards in the third world as they do here. I don't know.
I don't know anything about Coca-Cola except I like Diet Coke. But in all seriousness, sir, I think I'm correct in saying certainly most high-tech firms do the same benefits in Colombia as they do in the rest of the world. Because it's a global economy, and in the case of engineers, we trained 200 engineers last year in Colombia, and those engineers are in demand. Why would they come and work for somebody, work for us, and then go someplace or not work for us and work someplace where they didn't get the benefits? So I truly do believe, at least in the high-tech sector, that that the benefits will, over time, continue to raise the standards of living in the country.
All right, I'd like to take one more question if there is one. Otherwise, I invite you to enjoy a soft drink and a cookie. And we'll reconvene at 4:10. Thank you very much to our panelists.
Thank you. Thank you for coming.
We'd like to continue with this afternoon's program, but before we do that, I'd like to make a couple of announcements. First one, if you still need translation equipment, I'd like to remind you that outside we have equipment for your use. Please go ahead and take a transmitter if you need so. And secondly, if you have actually used the equipment, we'd like to remind you to please give us back the equipment, leave it at the front of the table as you leave the room this afternoon. We'd like to continue with a conversation on the U.S.-Colombia Free Trade Agreement. We'd like now to begin our discussion with Mr. Stanley Gasek from the AFL-CIO. I won't go into his many qualifications. You have a copy of the bios for each of our speakers. So in the interest of time and getting into the discussion, I'd like to invite Mr. Gasek to come to the podium, please.
Good afternoon to all, and buenas tardes a todos y a todas, nuestros colegas hispanoparlantes aquí. I want to thank Cynthia Arnson and the Wilson Center for this gracious invitation. It's truly an honor to speak on behalf of the 10 million working women and men of the United States represented by the AFL-CIO. What I'm presenting today is not a unilateral presentation of the AFL-CIO. what I'm saying today is in complete conjunction and solidarity with the largest and most unquestionably most representative of the national trade union centrals in Colombia, who speak for over 90% of organized labor in Colombia, both the private and the public sectors, including in sectors such as flour production, banana production, all agricultural areas, much of Colombia's export sector. And these include the CUT, the Unitary Central of Workers, speaking for 550,000, the CGT, General Confederation of Workers, speaking for 115,000 workers, the CTC, Confederation of Colombian Workers, speaking for 47,000 workers, and the CPC is the Confederation of Pensioners and Retirees of Colombia, speaking for millions of pensioners and retirees in Colombia. I'm going to present a very cursory overview based on this solidarity position between Colombian and U.S. labor with regard to the Colombian labor rights reality. Ambassador Schwab said in her eloquent presentation that seeing is believing. Indeed, seeing is believing. I actually had the privilege of being part of an AFL-CIO delegation to Colombia 2 weeks ago. And we saw, and we now are believing, with regard to that still there is very, very critical questions and very critical non-compliance questions when it comes to fundamental labor rights. It was very important for us to get that direct input from literally hundreds of workers and trade union leaders with whom we spoke from the representative sectors of Colombian labor, and then to relate our findings to representatives of the government, including President Álvaro Uribe. And indeed, Vice Minister Palacio is quite right. He did receive us, and we were very, very appreciative of that. We also reminded President Uribe that we're still waiting for that invitation from the current occupant of the White House. We haven't gotten it yet, but maybe there's still 9 months to go. Also, just one correction, however, with regard to what Vice Minister was saying. With regard to the invitation of the Consejo de Concertación, the Council on Harmonization, this was not an exclusive invitation to the AFL-CIO. This was an invitation to two representatives, and we were very, very gratified about this, to be observers. One from the International Trade Union Confederation, which speaks for over 170 million workers worldwide, and to the Trade Union Congress, Trade Union Confederation of the Americas, which is going to be formed officially in Panama in a month, and it will be speaking for approximately 50 million workers in the hemisphere. It was not an exclusive invitation to us. It's also great to share this panel with José Luciano Cenino of the Escuela Nacional Sindical. He and his organization are reliable, respected, and unimpeachable sources of information and statistics on the Colombian labor rights reality, as is the Colombian Commission of Jurists. So my intent is not to duplicate what he's going to be saying, but I want to emphasize just certain critical details with regard to labor rights reality. Lawyers love to start with caveats and disclaimers. I'm no exception, and so my first is that in these 15 minutes that I have, I'm not going to be able to review every aspect of labor rights in the country. Only freedom of association and collective bargaining rights, although those are very, very critical. And the second caveat, I am the ultimate Luddite when it comes to presentations. I'm still challenged with technology, PowerPoints, and so forth, so you won't be getting any of those. Unfortunately, you just have to bear with what I'm saying. Conventional wisdom, and we heard some of this conventional wisdom in the earlier panel, is that there must be sufficient progress with regard to labor rights because there have been large and impressive sums of money which have been committed, both by this government, the Colombian government, to dealing with Colombian labor rights, especially combating violence against the physical integrity of unionists. And that violence must be going down in Colombia because there's been a special focus on the decline in assassinations of trade unionists by comparing 2007 with 2006. A drop of 72 to 40 murders, albeit there have been at least 5 assassinations of trade unionists just this calendar year. So the questions come our way. What more do you people want? What are you saying? What are the goalposts? What are the criteria? What are you saying? In fact, one U.S. congressman who will remain unnamed actually accused us of moving the goalposts on occasion. And regrettably, we found ourselves in continuous debates on details and specifics, and today may not be an exception, unfortunately. But I think it's a very macabre and grotesque calculus to celebrate 40 assassinations as being real progress opposed to 72. But let me just also say the following facts remain incontrovertible. Colombia is still the most dangerous place on the face of the earth for trade unionists in terms of their physical integrity, and there continues to be a systematic, concerted, and designed destruction of trade union organization and collective bargaining in the country. And although our trade union central partners continue to speak for the vast majority of Colombian organized labor, out of a workforce of 18 million, trade union density now is arguably at its lowest point in the industrial history of the nation, at 4.6%, with those having actual collective bargaining coverage being at less than 1%. And just between 2003 and 2004, that collective bargaining coverage dropped an entire 23%. That's not an accident, because if one looks to the effects of concerted public policies, of privatization, anti-union reorganization of major state enterprises, and the legal imprimatur, the legal support for union busting and evasion tactics in the private sector, you know where that statistic comes from. So the current reality is not some accident. It's not a fluke. It's not due to some sort of lack of organizational volition on the part of Colombian workers and their organizations. Ironically and chillingly, the argument can be made that the murders of trade union activists and leaders are now not so necessary to crush unionization in Colombia, because it's already crushed for a lot of intents and purposes. We will recall the chilling words of the late AUC leader, Carlos Castaño, who said we destroy trade unions precisely for what they do. Well, the destruction is there. You consider public policies, state policies of liquidating public entities and the unionization with it, Caja Agraria, Telecom, Bancafé, Apostal, Banestado, just to name a few, and the private sector, the tactics, and apart from assassinations, of freezing of personnel and implementation of third-party contracting, cooperatives, use of temporary workers, as well as bogus bankruptcies and reorganizations, all have been used purposely to avoid unionization, crush unionization, and collective bargaining. And saying all this, we are not saying the U.S. labor movement that labor rights compliance is somehow a paradise in this country. Larry Cohen, president of the Communication Workers of America and the chair of our organizing committee of the AFL-CIO, told President Uribe directly that both of our nations need to work to turn around the situation, because arguably the U.S. and Colombia could be becoming the leaders in this hemisphere with regard to the assault on trade union density and destruction of collective bargaining integrity. So let me quickly go on to the question of the conventional wisdoms and some of the stereotypes that we've heard. We heard some of these in the earlier panel. And this is the reduction in murders, necessarily meaning reduction in violence, increase in committed financial resources combating violence and impunity must mean there have got to be results. And the Colombian government's proposals to change the law to achieve greater compliance with the ILO norms on freedom of association, collective bargaining, particularly with respect to cooperatives and the issue of right to strike. Now, due to the time constraints in this conference, I'm not going to be able to go into detail on protection policies for trade unions. But let me just say the following. No matter how many trade unionists you put into a program, you have got to look at the quality of what that protection is. And the mere requisitioning of cell phones, which is something which the Colombian Commission of Jurists has noted, is not necessarily quality protection. But even putting that aside for the moment, there is no protection. You can have 7,000, 8,000, 10,000 unionists in a system of protection. But unless and until you deal with the problem of impunity, because the intellectual and material authors of anti-trade union violence are still loose and are reorganizing, as the OAS itself observed in its report of July 2007, you're not going to be making real progress. And Luciano, I know, is going to be going into more detail with regard to that point, including the loopholes within the peace and justice law. And third, protection is not going to be effective if there are mixed messages coming from the highest levels of authority in the country. For example, unfortunate declarations by the Vice President regarding 3 union members assassinated by the Army in Arauca in 2004 having been fallen guerrillas in combat, when in fact they were not, and declaration against the entire trade union movement nationally because of participation of 4 unionists in a left-wing forum in Quito in July of 2007. So, solutions, recommendations, what are your benchmarks, what are you looking for? Well, I think a number of them should be embedded within my presentation. I've already made one suggestion that has to do with public declarations made by high officials within the Colombian government. But let me get specifically to the question of reduction in murders allegedly being a reduction in violence and committed financial resources to combat impunity. First of all, let's take this into consideration. Yes, there was this drop from 70 to 42 in terms of trade union murders. But also take this into consideration. Since the Uribe administration took power after 2002, there have been 470 trade union assassinations in Colombia. And consider this. If you look at violence in its entirety, there have been over 8,600 cases of violence against trade unions between 1986 and 2007, if we consider not only homicides, but physical assaults, forced disappearances, forced displacements, arbitrary and false detentions, death threats, kidnappings, and torture. The Escuela Nacional Sindical has concluded that 28% of that total has taken place in just the last 5 years, the most recent years of the current administration. Let's get to the question of judicial capacity to get real convictions, sentences, and minimally necessary detention of the intellectual and material authors of anti-trade union violence. The response of Vice President Santos to an inquiry by Congressman George Miller was basically that the 3 special judges were just fine to deal with everything. We've already heard the whole question about the temporary appointments, albeit by a board of peers for 6 months. That raises a whole other series of questions about really developing stability and expertise in the field. But putting that aside, the Vice President said to Congressman Miller, 3 are just fine, because we have to wait up for the Attorney General's office to fully investigate and indict on the 1,244 cases of their special subunit, which obviously is only a fraction of the total number of violence cases in the last 20 years. A little bit of logic is wanting here. Because if the Attorney General's office is really doing their job, we want them to do their job, we want them to have this capacity, these 3 special judges are going to be very quickly overwhelmed. And what about the Fiscalias? What about the Attorney General's current record on investigations and indictments? The Colombian Commission of Jurists notes the Attorney General's office has still not made clear how many of those 1,244 cases have actually been turned over to investigators. The Commission found that at least 206 cases don't have any files, which means they don't have any investigators. And the Escuela Nacional Sindical has pointed out that of the over 420 assassinations of trade unions that took place between 2002 and 2007, the Attorney General's office had information on 125 cases. In other words, on 29% of the cases they were supposed to be looking at. And of that 29%, 47% are at the preliminary stage, which means that a suspect hasn't even been identified. Now, the Uribe administration has been making public that they're now up to 82 sentences for those responsible for the nearly 2,600 assassinations since 1986, and that this is due to the establishment of special prosecutorial subunit and to the special judges. It's also important to note these 46 sentences of this amount actually took place before the establishment of either of those measures, and still 82 sentences makes for an impunity rate of 97%. Now, with regard to deliverables, tell us what to do. Well, the Escuela Nacional Sindical has a very, very important suggestion with regard to the presumptions in investigations, and I think it's so important I want to quote it briefly. Analysis of individual cases without considering reasons such as the consolidation of paramilitarism in different regions of the country, connivance of the state in many of the violations, occurrence of other violations against the same victim, even if caused by a different perpetrator. All of these divert the course of an effective investigation. And it must be presumed that when an act affects a union member, the motives can generally be linked to union activity, unless demonstrated otherwise. But the criminal investigations are going the other way. They are concentrating on the background on the victim and not on the motives of the perpetrator. This prevents a real establishment of the facts and identifying the intellectual and material authors. Want suggestions, want benchmarks? I think this is a very, very constructive one. Now, maybe because of the time, let me very quickly talk about the legal reality within Colombia aside from the question of direct physical violence. I've already mentioned a number of these, but I know that Luciano is going to go more into detail on this. But there is a structural problem with the denial and delay of union registration by the authorities, and there's the direct employer interference in this process, which has not been remedied. Temporary contracts, cooperatives, subcontractors, bankruptcies are all used to basically subvert union formation and collective bargaining. There's direct bargaining continues with employees to undermine union representation and collective agreements. There's been a denial of full collective bargaining rights to public sector workers. We actually look forward to the decreto, which the Vice Minister was talking about. This is very, very important, but the law still is not in effect now. So that's very, very important. There's still a ban on collective negotiations over pensions. There are no legal prohibitions on the blacklisting of trade unionists and union supporters. There's unjustified legal restrictions on industry-wide collective bargaining, and there's a denial of the right to strike in critical areas. Federations and confederations do represent workers on sectoral bases, and so to deny them that right is a clear violation of Convention 87, not to mention the problem
that the overbroad definition of essential industries is still there. And let me point out, the Antiproyecto, and I've read it carefully. We certainly think it's good that the Ministerio of Social Protection is not going to be able to declare unilaterally a strike unlawful, but there are these other very serious, even more substantive legal problems. And with regard to cooperatives, what the government has also said, and I've looked at that Antiproyecto very, very carefully, is they've said, no, we're going to be dealing with irregularity here because the return to workers, in many cases who've been forced to become members of cooperatives in order to basically maintain their jobs, this Antiproyecto basically only goes to guaranteeing that the return will be at the minimum wage and that there be sufficient contributions to the social security system. It doesn't go to the very critical question, which is, a cooperative is being set up in the first place in order to avoid unionization and collective bargaining.
So, in conclusion, I just wanted to say that looking to a slight drop in trade union murders between 2006 and 2007, and looking to increase the substantial financial resources going to the Attorney General's office does not make for a complete analysis nor a complete resolution of the labor rights situation. Funding must not only be committed, it must be intelligently and strategically applied. An decline in murder of trade unionists, albeit very critical, is not full comfort if one considers violence in all of its forms, which have led to a desolation of trade union organization and collective bargaining in Colombia. I'm just going to close with this comment. Please indulge me. Forgive me for harking back to Roman antiquity, but I do recall the words of Tacitus when he said, "They have called it a desert, they have created a desert, and now they are calling it peace." Thank you.
Mr. Gasek. We'll now hear from Mr. José Luciano San Velázquez from the Escuela Nacional Sindical de Medellín.
Buenas tardes. Sea primero agradecerle al Centro Internacional por Wilson la invitación, que le entendimos como una oportunidad más para que los temas laborales y sindicales de nuestro país se puedan debatir, se puedan colocar en una lectura plural y diferente como la que este panel ofrece, y sobre todo que de él salga un mensaje claro, un mensaje categórico para el gobierno colombiano y sus empresarios, de que es necesario introducir cambios laborales profundos en Colombia si quieren insertar el país en la dinámica de la integración económica. Yo quiero ofrecerles una lectura en dos temas, nada más. La intervención del viceministro me provoca muchas discusiones, pero voy a tratar de no hacerlo de esa manera. En Colombia tenemos más oportunidad, él y yo, de discutirlo que aquí. Quiero ofrecerles dos planteamientos. Uno, la convicción que tenemos de que el libre comercio, la libre empresa, sin derechos laborales y sin libertades sindicales es catastrófico. Eso produce resultados catastróficos. Esa es una de las varias razones que una institución como la nuestra tiene para hacerle objeciones al Tratado de Libre Comercio entre Estados Unidos y Colombia. Esa no es la única objeción, hay otras, pero digamos, vamos a sentarnos en esa. Y para discutir eso voy a mostrarles un panorama de cómo está eso en Colombia. Y lo segundo que quiero ofrecerles es que el tema de las libertades sindicales es absolutamente esencial para poder superar esa situación laboral que vive el país. Sin libertad sindical no son posibles los derechos laborales, no son sostenibles los derechos laborales, no son disfrutables por los trabajadores esos derechos. El primer punto, el panorama laboral de nuestro país. Aquí tengo algunas discrepancias con el ministro, hay maneras de leer las mismas cifras, pero vamos a ponerles simplemente esta cifra. ¿Qué mapa podemos hacernos? ¿Qué fotos nos podemos hacer de la realidad laboral colombiana? De cada 100 personas que trabajan en Colombia, ¿sí?, menos de 30 de ellas tienen contrato laboral. De esas 30 personas que tienen contrato laboral, 21 están haciendo el ahorro para su retiro. En Colombia se llama auxilio de cesantía. 25 están en la compensación familiar. 30 más o menos en riesgos profesionales, es la salud en el trabajo. Todos ellos están más o menos contribuyendo a la salud, al sistema contributivo de salud. 27 están ahorrando para su pensión, 5 están en un sindicato y 2 tienen un convenio colectivo de trabajo. ¿Sí? Ese es más o menos el panorama con cifras aproximadas laboral colombiana. Ese panorama nos está mostrando que el tipo de empleo y el tipo de protección social que tenemos en Colombia todavía es muy precario. Todavía es muy precario, excesivamente precario. Podríamos decir que menos de 1 de cada 3 trabajadores tiene alguna protección social en Colombia. Pero lo más grave, la gran mayoría de ellos no tienen un instrumento para lograr esa protección, una organización sindical, un convenio colectivo de trabajo. Y podemos decir, adicionalmente, que las políticas de generación de empleo y las políticas laborales que se están llevando a cabo en Colombia no van o no conducen necesariamente, todas ellas, a mejorar esta situación. Nosotros tenemos que reconocer que este gobierno ha hecho esfuerzos muy importantes porque el sector formal de la economía logre o realice o cumpla con sus obligaciones legales. Y esas son las cifras que mostraba el ministro. Hay unas cifras de mejoría en el recaudo del sistema de protección social, porque se genera un sistema integrado que permite controlar la evasión. Pero más allá de eso, la generación de empleo en Colombia no se está haciendo por el sector formal de la economía. Los sectores formales de la economía cayeron en empleo y los sectores más informales y más precarios son los que están creciendo en empleo. El sector comercio, sector servicios. Y precisamente el sector tradicionalmente formal es el que más está cayendo en empleo. Sector industria, Estado mismo. Lo otro que hay que caracterizar es que se está creciendo o se están generando de manera muy fuerte figuras en materia de empleo que son muy graves para la situación de los trabajadores en Colombia. El caso más típico es el de las cooperativas de trabajo asociados, figuras que no compartimos con otros países y que tampoco recomendamos que la usen, que se caractericen básicamente por construir una forma de trabajo donde no hay derechos laborales. A todo el mundo se le olvida contar ese punto. Es una forma de trabajo sin derechos laborales. Es decir, la ley acepta que los trabajadores se organicen para trabajar, pero entre ellos no va a haber derechos laborales. Es decir, no va a haber protección laboral como la tendría el trabajador con un contrato de trabajo. Entonces la característica básica de esas cooperativas es la precariedad. Tenemos estudios que pueden ustedes conocer en nuestra página web en 4 sectores de la economía sobre el uso de cooperativas de trabajo asociado, en la palma, en el azúcar, en los puertos y en la salud, y nos demostramos que los ingresos de los trabajadores y las condiciones de los trabajadores son precarizadas de manera muy dramática por los empleadores. Están en costos de entre el 50 y el 70% a lo que vale un trabajador con un contrato de trabajo, adicional a que esos trabajadores no se pueden organizar en sindicatos. Pero esas cooperativas, además, la gran mayoría de ellas son ilegales, y lo peor, el ministerio no tiene la capacidad para controlarlas. El viceministro no tiene sino 273 inspectores del trabajo para tratar de controlarlas, jamás las podrá controlar. En Colombia hoy, según nuestros registros, hay más de 3.000 cooperativas de trabajo asociado. Un dirigente del sector cooperativo me dijo a mí que eran cerca de 6.000, casi 1 millón de trabajadores en ese tipo de cooperativas. Es tan grave esa figura que hasta los negociadores del Tratado de Libre Comercio por parte del gobierno de los Estados Unidos se preocuparon por esa figura y dijeron públicamente que eso era dumping laboral. El gobierno no ha hecho mucho más por tratar de regularlo. Yo no creo que el proyecto de ley que esté tramitando en el Congreso resuelva el problema de la intermediación y la precariedad laboral. Encarecerle un costo a esa figura no la controla. Sí, creo que es una visión bastante optimista sobre el tema. Creo que lo que tiene que hacer la ley es prohibir la intermediación laboral a través de ellas y tratar de que se recupere el contrato de trabajo para esos trabajadores. El ministro debería estar muy preocupado de la huelga que hoy en Colombia de trabajadores del sector de La Palma pertenecientes a cooperativas de trabajo asociado, que salen a huelga aún sin sindicato y aún sin ninguna posibilidad de nada porque no tienen empleador, se supone que ellos son sus propios empleadores, y salen a huelga por una sola reivindicación: tener un contrato de trabajo. Puerto Wilches. Y pasó también en el sector del azúcar, y va a pasar y está pasando en el sector de las confecciones. Ese es el panorama laboral. Nosotros decimos, el libre comercio puede llevar a este panorama a una situación mucho más grave. Ahora el tema de las libertades sindicales. Yo les decía, en Colombia más o menos 5 de cada 100 trabajadores están afiliados a organizaciones sindicales. Algo así como 830.000 personas están en sindicatos. La mitad de ellas en el sector público y la otra mitad en el sector privado. El 70% de ellas están afiliadas a las 3 centrales sindicales existentes en Colombia. Esos 830.000 personas en Colombia tienen gravísimos problemas para poder funcionar. El que más conocen ustedes, por el que más se preocupa la sociedad en el mundo, es la violencia. Sobre esas 830.000 personas se ha ejercido una violencia la más feroz que se haya ejercido sobre el movimiento sindical en el mundo. Pero ese no es el único problema que padecen los sindicatos en Colombia. Tienen muchos más. Nosotros decimos que las libertades sindicales en Colombia están totalmente amarradas, totalmente sujetadas, tanto por la violencia como por el discurso antisindical que se establece desde el gobierno, como por las prácticas del gobierno y de los empresarios, como por las normas jurídicas que la regulan. Es decir, las libertades sindicales en Colombia están estranguladas, insisto, no solo por la violencia, sino también por el discurso, las prácticas y las normas. Voy a mostrarles ese panorama. En primer lugar, el panorama de la violencia. De nuevo tenemos discrepancias con el gobierno, discrepancias hoy menores a las que tuvimos en alguna época, porque en alguna época el gobierno registraba más homicidios que nosotros. ¿Sí? En el 2001 el gobierno registra más homicidios que la Escuela Nacional Sindical. Sin embargo, en el 2007 somos nosotros los que registramos más homicidios. Y eso tiene que ver con un problema de metodología, de cambio metodológico del gobierno, no de cambio metodológico nuestro. Nosotros llevamos 18 años haciendo seguimiento a la violencia antisindical en Colombia, y siempre hemos entendido lo mismo por violencia antisindical: todo acto que atente contra la vida, la integridad física o la libertad personal de los afiliados a organizaciones sindicales. Ahí entendemos los homicidios, las desapariciones forzadas, las torturas, los allanamientos, las detenciones arbitrarias, los hostigamientos, etc. Y lo registramos de manera sistemática, y lo registramos desde hace 18 años, cuando este tema no era un tema importante, era un tema que solo nos preocupaba a algunas organizaciones de derechos humanos y obviamente a las organizaciones sindicales. El ministerio ha cambiado la metodología y quieren delegarnos su cambio de metodología a nosotros. Las diferencias que tenemos tienen que ver con eso, lo tenemos claro entre el viceministro y nosotros. ¿Cuáles son las diferencias? Para nosotros el año pasado fueron asesinados 39 personas pertenecientes a organizaciones sindicales. En lo que ha ocurrido este año han sido asesinadas 5. En los últimos 22 años han sido asesinados 2.554 personas pertenecientes a organizaciones sindicales. Eso nos hace ver que la violencia antisindical es un fenómeno histórico en Colombia, que ha permanecido en la historia de Colombia. Es un fenómeno que no es episódico, que no es un momento histórico, es estructural en nuestra historia, pero también nos está señalando de que la violencia antisindical es un fenómeno actual. No se ha dejado de ejercer violencia contra las organizaciones sindicales en Colombia. Ya lo decía Stanley, en el gobierno del presidente Álvaro Uribe Vélez han sido asesinadas 420 personas pertenecientes a organizaciones sindicales, y se han cometido cerca de 2.800 hechos de violencia contra personas pertenecientes a organizaciones sociales. Eso muestra que en los últimos 5 años se ha ejercido violencia antisindical. Otros 3. Se me fue el... Bueno, pasate de esta discusión. Bien. Es una violencia histórica, es una violencia actual, y es una violencia que a nuestro modo de ver es una violencia deliberada, es decir, tiene una intención: impedir el funcionamiento de los sindicatos en el país. no es una violencia, por tanto, colateral o fuente de otros problemas en el país. Alguna de ellas, muy residualmente, podrá tener esa explicación, pero la gran mayoría de los actos de violencia se hacen para impedir que los sindicatos funcionen o para castigar la actividad sindical. Hay muchas formas de contar esta historia. Yo los invito a que estudien el libro que hicimos sobre esa historia de la violencia antisindical en Colombia, que también está en nuestro sitio web. Esa historia también es una historia impune. Esa historia de violencia antisindical es una historia impune. Ya lo decía Stanley, las cifras de la Fiscalía reconocen que solo en 82 casos hay sentencias, de los 2.554, es una impunidad del 97%. Sin embargo, a nosotros nos preocupa algo mucho más de fondo que la cifra. La cifra de impunidad nos daría que, yéndonos bien con los actuales fiscales y los actuales jueces, en los próximos 40 años vamos a superar la impunidad. Hagan la cuenta. De 2.500 al ritmo de 40 sentencias en 40 años, 50 años, podremos superar la impunidad. Pero nosotros no ese es el problema es de calidad. Las sentencias y la manera en que se está investigando la violencia antisindical en Colombia están olvidando por lo menos tres cosas, para decir las más importantes. Están olvidando la dignidad de las víctimas. La Fiscalía está informando acerca de la violencia antisindical sin consideración a la dignidad de las víctimas. Es capaz de hacer un informe diciendo que ha avanzado en la superación de la impunidad, diciendo que en 15 casos la persona fue asesinada por pertenecer a un grupo armado ilegal, que en Colombia significa por pertenecer a la guerrilla. La Fiscalía no puede informar eso en un proceso que se sigue contra el victimario. Si el proceso se siguiera contra la víctima, lo podría afirmar. ¿Y cuál es la fuente de eso? 20 confesiones de paramilitares que han dicho que han asesinado a dirigentes sindicales por ser guerrilleros. Todos los paramilitares dirán en Colombia que a todos los asesinaron por ser guerrilleros. Es un conjunto de sentencias también que no están reconstruyendo la verdad histórica. Yo lo quiero mostrar de esta manera. La violencia antisindical no la vamos a entender si seguimos analizándola tratando de ver el árbol y no el bosque. La violencia antisindical en Colombia es un fenómeno muy complejo, de lógicas muy entrecruzadas entre intereses económicos y políticos e intereses con grupos armados al margen de la ley, que no se puede entender estudiando caso a caso. Nosotros creemos que la violencia antisindical en Colombia se debe estudiar y se debe investigar como un genocidio, y por tanto las unidades de fiscales y de jueces deberían estructurarse de esa manera. Y allí la importancia de que los jueces no sean temporales, y allí la importancia de que la asignación a los fiscales no sea ocasional, porque necesitamos una investigación integral que pueda comprender esa lógica. Pero al mismo tiempo necesitamos que una unidad de jueces y fiscales sea independiente. Un juez no podrá ser independiente si es nombrado cada 6 meses, no tendrá la posibilidad. Por eso yo discrepo del viceministro del caso del juez Sánchez. Ya se lo dije al congresista Miller. En el caso del juez Sánchez, yo no creo que la razón de que él lo haya seguido es porque esté en edad de jubilación o quiera irse, sino porque él sacó las 2 sentencias más importantes que han sacado los jueces de descongestión en materia de asesinatos de sindicalistas. Sacó la sentencia de la Arauca, en la que se juzgó a militares, en la que se condenó a militares, en un caso en el que el alto gobierno, presidente y vicepresidente, habían dicho que eran guerrilleros, y este fiscal dice, no eran guerrilleros, eran sindicalistas que fueron ejecutados sumariamente por militares. Y en el caso del asesinato por parte de los paramilitares de un trabajador de un sindicato perteneciente, de un sindicato que hace presencia en una empresa de la Nestlé. Este juez dictó una sentencia ordenando que se investigara la Nestlé, al empresario. Son las 2 sentencias más importantes que nos están mostrando la lógica de la violencia antisindical, y yo entiendo, por tanto, o por lo menos me reservo la posibilidad de pensar que no lo sacaron porque estaba en edad de jubilación, sino porque estaba tomando sentencias que afectan de manera muy grave a actores importantes de la sociedad. Y ya me han dicho que termine, entonces voy a tener que pasar por todo lo de libertades sindicales, el tema de la huelga, del registro sindical, de la negociación colectiva, el tema de la inspección del trabajo, etcétera, etcétera, para hacer la conclusión. me pasó lo mismo que le pasó al ministro. ¿Cuál es el punto? ¿En qué punto nosotros queremos ubicarnos en esto? ¿Cuándo vamos a entender que hay progreso o no hay progreso en la situación laboral y sindical en Colombia? Si no fuéramos al maximalismo, tendríamos que decir que Colombia estaría bien cuando haya cero personas pertenecientes a organizaciones sindicales asesinadas y haya un 100% de verdad y justicia frente a todos los crímenes cometidos. Y eso debería ser un acuerdo de todos, eso no lo podemos negociar. Creo que no podemos negociar un porcentaje de impunidad y mucho menos un porcentaje de asesinatos. Pero tal vez lo más importante que nosotros entendemos para esto es que yo creo que el momento en que podemos ver un progreso en Colombia es cuando la libertad de empresa sea igual a la libertad sindical. Es decir, cuando los sindicatos tengan las mismas posibilidades de funcionar y existir y ser reconocidos en la sociedad y no ser atacados por su actividad y no ser hostigados por su actividad y no ser delegitimados por su actividad, como la oportunidad que tienen los empresarios de existir en el país. En Colombia a una empresa no se le niega el registro sindical, a una empresa no se le estigmatiza por parte del Estado, a una empresa no se le asesina por ser empresarios, ¿sí? En cambio a un sindicato se le niega el registro sindical, se le estigmatiza ante la sociedad, se le asesina por ser sindicalista. Ese día, el día en que en Colombia la libertad sindical sea bien parecida a la libertad de empresa, tenga las mismas garantías y el mismo reconocimiento social, creo que ese día estaríamos hablando de progresos en materia de libertad sindical y en ese día no tendríamos los riesgos que se tienen hoy y las limitaciones que se tienen hoy para ejercer. Muchas gracias. Que termine. Entonces,